are at 1 o'clock, so do we have a quorum? We've got Barry and EJ and Joel and myself. We have a quorum with that 5, so
You might have to speak up just a little bit, just to make sure.
all right, we've got a quorum. We're gonna go ahead and get started. Brett, you wanna call roll?
Dan Breitbart, Joan Corbin, EJ Giovanetti,
Here.
Barry Little,
Here.
Joel McCray, here, Kevin McHugh,
Here.
Julie Potter,
Here.
Jackie Spellin,
Here.
yes, board members present.
So let's go with the approval of the agenda. Do I have a motion and a second?
So moved.
Second.
Barry.
Julie already
Yeah, Julie already got you first. So Joel and
Got it.
all in favor?
Aye.
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 All right, the approval of the December 21st minutes. Do I have a motion and a second?
I move. This is EJ.
AJ moved. Julie
Second.
was-
Second.
Barry second. All in favor?
Aye.
Aye.
Comments from the board chair. The only thing that I have is that we are trying our system out today called the OWL to record and with the system. So that's really the only thing else. I don't think I've got anything other to say. So we'll see how this goes. If it works, then we'll be purchasing this for the rest of our board meetings.
I just want to,
Oh,
before we go back to that, can I just say, if anyone has trouble with there should be a live feed on our YouTube channel. If you're having trouble trying to get in, we do, for this meeting, have the conference call option still to make sure that this is accessible.
okay. Do we have anybody from the public who would like to comment? You can also wait for your case. All right. So we do have an advisory opinion pending. And let's go ahead and go into the cases. Erica, you want to
All right.
start?
So the first case is Todd Banner and Iowa State University, case number 23 FC 0086. This case, this is a revised dismissal order. This case was before the board last month and was tabled for some additional information. In this case, Mr. Banner filed a formal complaint alleging that Iowa State University had violated Iowa Code Chapter 22. He filed a records request related to the boundary between an ISU property and an adjoining property owned by Swamp Flats Properties. This was divided into 3 separate sub-requests. In responding, the Iowa State estimated the records would cost $1,590 based on estimating 54 hours of labor. The actual time spent completing the request was 49.5 hours, and the total cost was settled at $1,455. After receiving the responsive records from ISU, the complainant filed this complaint. He had 2 allegations that ISU did not provide all the records requested, and the fees charged for the request were unreasonable. The board took this up, as I said, last month, and had some additional questions regarding the fees and the records. The Iowa State has provided some additional information. The search terms requested by the public records request resulted in an identification of 248,904 pages of records that all had to be reviewed at some level. The review of these records took about 49.5 hours. Some of the files also contained video, Excel files, PDFs, and other larger data items that were not related to the request. The amount of data was a direct result of a broad request. There was some questions last month about what was included in the amount of data stated by the Iowa State. The request also sought documents related to the property boundary issue. So that required that the university produce all records that hit the identified search terms. If they had produced all, had required to produce all records that were identified, rather than just the related records, the review would have taken much longer, as many records would have included student, employee, or other confidential categories of information. As they were deemed not to relate to that boundary dispute, they were not reviewed for other confidentiality. Again, many more hours would have been needed for that. In reviewing the reasonableness of the charge, in reviewing it, the conclusion was the completion of the records request charge was not unreasonable. The individual public records office who reviewed the records is compensated at a rate of $32.60 per hour. The records request was only charged $30 per hour for that time spent. Again, that the charge did not exceed the actual cost, and the amount of time spent reviewing the records based on 248,904 pages of records is not unreasonable that it would take that length of time. The other issue was that records were withheld, in that Iowa State stated that all records that were withheld included privileged attorney-client communication or attorney work product that's confidential under 22.74. There is a ongoing legal dispute regarding the property that was identified in that, and the complainant argued that work product should not apply to any records withheld because of the absence of litigation. However, work product does not require active litigation under interpretations from Iowa Supreme Court. There is a property dispute over that, and so it's not unsurprising that there would be records concerning these that are confidential based on attorney-client or work product. In conclusion, the charge for the records was not unreasonable based on the number of records and the fact that they were charged for less than the actual cost of providing the service. The amount of time spent on that, given the scope of the request and the nature of the records, is not unreasonable. Also, it is complainant, Iowa State was not obligated to release attorney-client privileged communications or attorney work product emails. Other documents were released. So based on this additional review, additional information, the recommendation is a dismissal.
All right. Mr. Banner, would you like to speak? You good? 5 minutes?
Thank you all again for your time today. In the last meeting, Mr. Norton from Iowa State University told you that 99.98% of 9.8 gigabytes was entirely client attorney privileged material. I pointed out the absurdity of having hundreds of thousands, if not 1 million pages of attorney privileged information, and you asked to follow up on ISU's claim. Thank you. ISU has now admitted that there were indeed about 249,000 pages of records and have changed their tune that a significant portion of those records were not privileged after all. How many pages are not privileged? We don't know. Either Mr. Norton was not being honest with you last time, or maybe he doesn't know sufficient details to render accurate comments. Either way, this should be a red flag to you. It's now obvious that my requests for records were not met. If you recall from last time, in my request, I asked for all records with the keywords from 7 individuals. ISU claimed that 49.5 hours were worked to determine which records, but those search terms were related. Again, I did not request that they be related to anything. I provided clear and concise search terms that were intentionally not met by ISU. And in our last meeting, Mr. Norton even admitted that they did not follow the request. They had simply assumed that I wanted those records related to something. I'm sorry, but a general counsel of a major state university should know better than to charge $1,455 based upon an assumption. In addition to ISU admitting that it did not provide the records I had asked for, your revised dismissal order also acknowledges that they did not provide them because they were not related to an issue. It's all on page 2 of your revised dismissal order. How more clear can it be that my request was not met? Furthermore, ISU claims that in the process of determining what was related, again, something I didn't ask for, that an employee reviewed 5,208 pages per hour or 85 pages per minute for 49.5 hours. That's more than 1 page per second of text-based records. Do you know anyone that can speed read that fast? Many responsive records would likely have been missed over the course of this sloppy evaluation. Maybe that was intentional. This is exactly why I provided crystal clear search criteria in my request, which ISU and your dismissal order admits was not followed. ISU claims that my search was broad and generated 249,000 pages of records. In contrast, I believe that my search terms were fairly narrow, asking for keywords from 7 individuals that included boundary, fence, swamp, or fox, or swamp fox, or banner. These are not extremely broad search terms. How many emails per day do you receive with those keywords? Well, it turns out that these 7 individuals claim to each have received on average 35,558 pages of records, or 58 pages per day, every single day for 617 days. Does that seem ridiculous to you? Why would ISU want to claim that hundreds of thousands of pages turned up in what I believe to be reasonable search criteria with far fewer pages? I'm asking you to not dismiss this complaint. The facts are clear that my request was not met and records are being withheld. I believe it's unlikely that 249,000 pages of records containing my search criteria even existed in the first place. This would mean that the costs were unreasonable. There is zero evidence that ISU actually processed 249,000 pages of records. The records have not been provided, and ISU is unable to provide a standard itemized invoice listing when the 49.5 hours are worked. I believe that the search was either conducted with errors, or maybe this is fraudulent invoicing and a Class D felony. I asked the board to use its authority under Iowa Code 26.6 to verify that 249,000 pages were indeed generated and they met my search criteria. If you recall last time, ISU claimed that all records withheld were all attorney privileged and that you had no authority to review them. ISU is now stating that not all retained records are attorney-client privileged after all. So you do indeed have the authority to review these otherwise confidential exempt records. How many of the 249,000 pages are not attorney privileged? How many records did ISU not provide per Iowa law? Again, thanks for your time today.
We have someone from Iowa State who would like to speak.
Mr. Norton says that he had a conflict. I don't know if he was able to get online or not.
Mr. Norton, are you on the phone? All right, do we have any comments from the board? No comments. Do I have a motion on the dismissal order, on the revised dismissal order? I have a motion from Julie to approve the revised dismissal order. Do I have a second?
I would second.
And Joan is seconded. All in favor?
Make sure you give everybody a chance.
Aye.
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 EJ?
Aye.
I'd abstain from that.
All right, the next one,
That is 7-0 with one abstention.
All right, Brett, are you comfortable with the Redfield Public Library, or you want me
I
to?
guess, yeah. This is an informal resolution report. We submitted the informal resolution to the school board, the library board, as well as the two complainants. And we have, they've all agreed to that resolution, which included training. If you remember, this is an issue where the Public Library Board was holding meetings that they didn't consider to be meetings. They called them informational meetings or not official meetings. And so training has already been set up and actually was going to happen last week, but we did have that snowstorm. So they moved that training to February, which is within the 60 days we've allowed in this resolution. So
All right, do we have anybody from the case, Leslie Wiles or Coletta Cox, who would like to speak to the resolution report? Or anybody from the Redfield Public Library? Any comments from the board? No comments. If I have a motion to approve the informal resolution.
So moved.
second.
Barry,
Dan beat you out, Barry.
somebody beat me again. Okay.
All right, all in favor?
Aye.
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 Any opposed? All right. Resolution report has been approved. Third case, Joseph Foreign.
So this is Joseph Foreign concerning City of Audubon. This is case number 23 FC 0098. In this case, Mr. Foreign alleges the city council is conducting meetings via email and outside of public meetings with the exclusion of one council member. He provided emails to back up his allegations. In response, the city stated that the email communications may have included a majority of the city council, but the communications involved were on only ministerial or social issues rather than deliberative matters within the scope of the city's policymaking duties. In reviewing this, the importance was to look at whether or not a meeting occurred based on the email communications, and did review the emails. Several emails were reviewed. A majority of the council was copied on all of these. However, at no point in any of the emails did a majority of the council participate in the discussion. In reviewing the content of the emails, there was content that would be within their policy scope, so there was deliberation. However, with no email including a majority of the board, other than through just a passive being copied, based on previous formal complaints that have been reviewed by IPIP, passive being copied on an email did not create formation of a meeting when there was no active communication among all members. I would state that while there is no meeting under these particular facts, email chains can constitute a meeting in violation of Chapter 21, and it is prudent for government bodies to avoid engaging in deliberation through electronic means and avoid sending mass communications to ensure that there is no improper meeting created. So we recommend dismissal based on these facts.
Is Mr. Foreign available? Would he like to comment?
Yes, I am. Thank you very much. Can you all hear me okay?
Yes, we can. Thank you.
Okay. In my role as the then city clerk at that time, I witnessed multiple times in which there was discussions, both email wise and outside of meetings. I think along with the emails, I provided a notes of a meeting in which there was a committee formed in which they went ahead and already decided to meet with individuals that the one city council member had decided to be on the committee, and then later approve said committee. That's just showing that, I mean, it's habitual that, they're doing things outside of meetings in terms of, in that case of setting up a committee and actually, how do I want to say, having it have authorization and everything without even going through the council first. As for the emails, there's one particular councilman who is newer, that has been warned. As I show in the emails there in June, one councilman specifically warned him, and he continues to reply all to every email, even though he's been warned about the issues that you have just stated about email chains and the like. So.
Thank you, Mr. Corey. Is there anybody from the city of Audubon who would like to speak?
Yeah, this is Theodore Warnio, attorney for the city of Audubon.
Okay, Mr. Hunt. All right, you've got 5 minutes.
And I'll be very brief. I appreciate everybody's time here today. I think what we have here is, unfortunately, I think we've got a disgruntled ex-employee who is, I think, more frustrated with the city council about his previous employment than he is frustrated or concerned about whether or not Chapter 21 was violated. These emails that were obtained unlawfully. The request was made by the claimant to the IT department for these emails. That's not how they process the procedure for the city of Audubon works. There's a code section that requires these requests to be run through my office. I wasn't aware that these emails were obtained by Mr. Thorne until after the fact. So I didn't get these emails really until 6 weeks ago. So they were obtained improperly for, I think, purposes, again, unrelated to Chapter 21. With respect to Chapter 21, I don't believe the council violated Chapter 21 in any of these emails or any of their actions. I think there's a couple of emails that were cited specifically by Mr. Thorne from one of the council members. I think it's important that we take a look at the intent behind these emails and who sent them. And if who sent them is important to note at the intent. It is an older gentleman on the council, and I think Mr. Thorne would agree, because I've been at several meetings now where the individual who's being has been alleged to have violated it struggles with email. He struggles with all technology. I've had a discussion with him directly, and he said, "Look, I was just responding to an email. I didn't mean to respond at all." And I believe he did not intentionally or with bad or evil purpose even attempt for there to be a meeting by email. But again, I don't think there even is a meeting. I think the board found correctly that it was not violated, and we request that the board vote in our favor. Thank you.
Thank you, Mr. Warnio. Comments from the board?
I'm happy with the dismissal, but I think we're getting awfully close to just discouraging people from using email. And it's a convenient tool. You're not going to have a meeting unless people wind up chatting simultaneously, and the majority is there, no matter what the content of the email is. And I've always thought, if you can't even see that everybody got the email because nobody wants the chance that people will chat, that seems unduly paranoid. But I certainly agree with the dismissal order.
I try to put myself in this position as a chair of a public board, and I just, recently we're having opportunity for advocacy, and it involves all of the board members, and I'm so cautious about someone accidentally replying all or anything that I tend to do it informationally to one board member at a time. And I don't know, I mean, I know that's not efficient, but was the part of replying all happenstance, or was that the meat of this? I mean, was that just an add-on kind of thing, or was it more that this all went out, but not to a majority of the board?
It went out to so there was, usually it started with here's some information to the board. So one of them was about a city that they worked in had gotten a grant. Are we doing anything on grants? And sending kind of an information out to everybody. And then there was a reply to everybody from the city clerk, and then a reply from somebody else about, I looked up this. And so some of them were just informational. Some of them were about, here's a quote for our comprehensive plan. And there was a reply about how it was too expensive and this, and whether it's a good idea. And so there was some of that deliberation reply all, but the issue was that these were originally sent out informationally to the entire board, and then a discussion occurred.
And the discussion was with not a majority.
So everybody was copied on it, but a majority did not participate.
Thank you.
Well, at the risk of being repetitive, I think it just borders on paranoid. I think people are all gonna read and then get back online at the same time so that you have a majority. I wouldn't want to impede public bodies from using email. Efficient dissemination of information.
I think the official dissemination is fine. I think it's when they start to engage. I know you synchronous, asynchronous, but I think once you start deliberating through those email channels, then you start creating, then you're outside of the public view. If you're deliberating on issues within the scope of your public policy.
I would fully agree with that.
And I know that there's a question about whether or not an asynchronous meeting can occur, but I also think that if we're looking at transparency, ensuring that there's not this deliberation outside of an open meeting would be a better practice. And I think at what point does it become a meeting if you have that ongoing deliberation?
It becomes a meeting when a majority is online at the same time, chatting about it. And that seems to be unlikely.
What did you say?
Unlikely.
So any of the emails that the discussion that they had, did those issues show up on an agenda for an in-person meeting or for a scheduled meeting?
I did not check that because there was not a majority of people involved.
Okay. Does anybody else? Dan, you have any
Yeah,
comments?
I agree with the recommendation. I also agree with Julie's comments that I don't think we want to be suppressing local governments from getting work done efficiently. But I disagree with the attorney for the city. To me, the second bullet, an email is sent making a recommendation regarding a specific wage adjustment. That to me seems very specific and pointed and could elicit deliberation if a majority would have participated. And I think that's what we're trying to prevent here is decisions being made outside of the public scope. And I don't think that's happened here. And so I agree with it, but I think this is a pretty close call, actually.
And I would say if I had a board member who, for no fault of their own, but just didn't understand how to use email and not reply all, I probably would email them separately, just to be sure that that wouldn't accidentally happen.
All board members need to do is just copy everybody on their reply. If you don't make it reply all. When I was first on the board, I wondered, why am I the only one getting this email? Until I found out they just weren't copying. It should have copied everything.
Yeah, the blank copy.
Yeah, and and the details of it just needs at the end of the book. That's odd. All right, I'm done.
I move to accept the proposed dismissal order this time.
I have a motion. Do I have a second?
I was waiting for Barry, but I'll second.
Okay. Dan and Julie, all right, all in favor?
Aye.
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 Did you ask for opposition?
Did what?
Have you asked for?
Not yet.
Okay, sorry.
Uh, Barry, are you still out there? Or you did okay? Thank you.
And Matthew.
Okay, all right. Any opposed?
I,
Okay.
just point of order, Monica. At one time, we had a discussion about also after motion and second and
Yes.
asking for
Yep.
comments. So thank you.
And I probably would be difficult, frog, owl, whatever will discourage. But, I don't know that the board ever adopted Robert's Rules of Orders. It always seemed backward to me to make the motion up front and then have the discussion, because out of the discussion, you might decide to put the motion differently. So that's, I guess, why I never conformed. It seemed to make sense to have a discussion and then decide what motion was appropriate based on that.
And sometimes boards do both in.
That's true.
I think in a couple meetings ago, we decided to adopt the policy of having the motion and then allowing for additional comments if there were.
And I think that doesn't, without belaboring this, that doesn't preclude the idea of having conversations, you know, what's appropriate for the motion. I don't think, I think those are okay. Thank you.
All right, Hendrick Van Pelt, City of West Des Moines.
All right, this also is a case that was tabled from last meeting. In this case, Mr. Van Pelt alleged the city did not provide all the records he believes should have been included in his records request that he made in October of 23. Specifically, he asked for a copy of the agreement between the City of West Des Moines and Flock Safety, including any addenda like the deployment plan and reinstall fee. He claimed that he should have received the documents that were incorporated by reference. In response, the city stated that it provided a response to his request, which included copies of an April 23 agreement and July 2023 amendment between the city and Flock Safety. He replied he requested a reinstall policy and a deployment plan he believes should have been there to complete the agreement. The city responded and verified that the records provided included all the records that were within the city's possession. The city explained that the company creates and retains the deployment plan. It is not retained at the city. The deployment plan is basically a working map created and maintained by Flock. City reviewed a map online to approve it, but did not create the map, print it, or save the record in any means. And as far as the reinstall fee schedule, no document was provided to the city. The city contends since the record was not retained by the city in any medium, it does not meet the definition of a public record under Iowa Code 22. Following the board meeting, staff was asked to seek additional information from the city regarding their questions. The city did respond through their attorney that they do not possess the records identified as the deployment plan and reinstall fee schedule. And they indicated the city would not go out and acquire documents from a third party as that is not required under Iowa Code Chapter 22. The city further contends they provided Mr. Van Pelt all the records in their possession. Under Chapter 22, the city does not have to create or retain documents from a vendor. There are no retention requirements under Chapter 22, as there's no retention requirements and there's no requirement to create a document or recreate a document from another source. There's no violation under Chapter 22.
Mr. Van Pelt, are you online or, oh, that's right, I'm sorry, that's what I'm doing.
Yes, I would like to speak. So, yeah, first, I'm not entirely sure why we are here today. As Ms. Eckley pointed out, it was tabled last month to gather additional information. It appears that no additional information was actually gathered. Staff requested the same information and received the same response from the City of West Des Moines, which is that we had the documents, we did not retain or we disposed of the documents, and therefore we do not have to provide you the documents. That's the same situation that we were in last month. That was discussed here, and it seemed there was some sort of consensus that an agency should not be able to just, not keep documents or destroy documents or whatever it is and say, well, we don't have it, therefore it's not public information. That's basically the same thing I said last month. I still think that holds true, especially given that there's no new information. These are not addenda as such. I would like to point that out. There is a clause in the agreement between the City of West Des Moines and Flock Safety stating that the entire agreement is the document that I was provided with, which I'm blanking on the title, but yeah, Terms of Service, Master Service Agreement, it's one of those. It is that plus the deployment plan plus the reinstall fee schedule. All of that comprises the entire agreement, which is what the City of West Des Moines signed on to for, off the top of my head, in the order of $500,000. The fact that this is considered now to be a working map that is, for some reason that is unclear to me, the property of Flock Safety. Nowhere in the document does it say that it is the exclusive property of Flock Safety. It just says it's part of the agreement. But if we were to assume that that is true, then Flock Safety could unilaterally modify the deployment plan, which would include moving their devices throughout the City of West Des Moines. Because the city apparently approved it and has no recourse to compare what they approved versus what Flock has available. That would bring a host of practical problems, not least of which that the city is responsible for providing and obtaining permits for installation of this hardware. So if the city is installing these permits on DOT managed roads, the city will have to work with Iowa DOT to obtain a right of work permit to allow Flock to install the cameras. If the city has its own ordinances related to placing private property on public roadways, then those permits would have to be in order and issued to Flock Safety. So to say that Flock Safety can unilaterally just modify their deployment plan, the positioning of their devices within the city it seems unwise to me, if I just put it politely. So yeah, for that reason, I have some trouble accepting that the city just did not maintain a copy, that it is in some way, a reasonable policy for the city not to do that. It seems very much to me that this document was not retained or, otherwise disposed of because it is not a document that the city wants to be public. That would be kind of an end run around Iowa's open records law. Basically, you can take part of an agreement and say, we don't have it anymore. Good luck. I think that is very, very problematic. I think at a very minimum, I don't think my complaint meets the criteria for dismissal, which would be that on the face of it, it would be legally insufficient. I don't think that's the case. I think it is very debatable whether or not the city should be providing this document, should be obtaining it from Flock. It exists. Yeah. So I'm asking the board not to approve the dismissal order and to consider accepting my complaint and investigating this further. Thank you.
Thank you. Do we have somebody from the City of West Des Moines?
Thank you, Board. Jessica Grove, Deputy City Attorney for the City of West Des Moines. First of all, my apologies for not being here in December. I myself had a medical appointment that I could not miss. So that was my absence. I did get an opportunity to listen to the recording from the December meeting. It seems like Mr. Van Pelt's comments are similar to that which he spoke about in December. I'll quickly address a couple of those. First of all, the allegation that we in some way destroyed or shredded this information is completely false. And I object to the insinuation that we would intentionally destroy of a document that could be determined to be a public record. That in no way happened. The document was never printed, was never saved in any electronic or other means at the city of West Des Moines. As far as the statement, I'm going to address the reinstall policy fee schedule first. I think that one's pretty simple and easy in my opinion. As was stated the last meeting, I believe by Ms. Eckley, there is a full URL provided in the agreement, which was obtained by Mr. Van Pelt. We provided it actually just one day after his request. And that the reason that the city did not print or save that is, if you will note in the contract, it does actually in fact state under section 2.7.1 that any basically reinstalls, as they're called, if we need to move or replace a camera, it is charged at the then current list price for the reinstall as listed on the then current reinstall policy, and it provides the URL. What would be the point of the city saving a pricing that is subject to change? We agreed to these terms. Our council felt that it was appropriate to agree to terms that could change in price, and that was done at a public meeting. That document was not saved because it's a then current pricing. The URL still works. I checked it yesterday. Mr. Van Pelt has access to that through this agreement. So again, one, it's not a public record because the city never saved it. It does not meet the definition under Iowa Code Chapter 22, but he does have access to it. So that record, I think, is pretty simple, not something that he needs to obtain from the city when he has public access to it. Now, to get to the deployment plan, I think there might be a misunderstanding or maybe a misconception of what the deployment plan is. The deployment plan is a working map. It is something that as the locations of these cameras are determined of where they're going to be placed, they are determined by Flock. Flock is a company that operates nationwide. I have the Assistant Chief of Police here with me today, Jody Hayes. He's the one that manages our relationship with Flock. If we do have any specific questions about the system and how it works, he's very well versed. City of West Des Moines had these cameras since 2020, a lot longer than, I think we're the first in the metro to have these cameras. None of them are placed on any county road or any state-owned or federally owned roadway, so we did not need to obtain any permits. So that is not something that Mr. Van Pelt needs to be worried about. They're all placed on either private property with permission of the property owner from the city or on public light poles or traffic signal poles. But as far as the deployment plan, it is a link that is sent via an email that is clicked on, looked at, and approved. It's edited, maintained, retained on the server of Flock. It is not maintained by the city of West Des Moines. As you can imagine, a city of our size, we have contracts with many entities. We have contracts for engineering projects, and those include for roadways. We don't keep all of the design plans for our roadways. We keep the final document. The deployment plan is something that is approved periodically. We know where these cameras are. We're not trying to hide them. They're visible to the public. They're not hidden by any faux greenery or anything of the sort. We're not trying to disguise them. If you're driving on a roadway, it captures a picture of your license plate. Being able to drive on the roadways, it's a privilege. It's not a right. Also, you're in public, so the visibility of your license plate is open to public view. I don't know. I agree with Mr. Van Pelt. I quite frankly didn't see this coming back in front of the board. If you look at the plain letter of Chapter 22, the city is not the lawful custodian of the deployment plan. And by Mr. Van Pelt's own admission in his submission to the city prior to coming to this board, he asked us to re-obtain the record. That was never the intent of Chapter 22, to ask municipalities to reobtain records that they are not in possession of. If we had destroyed a record, I completely understand us trying to get around the law, but that is not the case here. This
Thank you.
bottom
That's
line's not a public record. Thank
coming
you.
from the board.
This is Barry. I just have a question. So there's no way that anybody can access this deployment plan now?
Yes, we have access to it, but we don't maintain it. It's similar to, I guess I would argue a working map of like a GIS system that, those are obviously maintained typically by the city, but it's a map that we have access to. We typically don't need to and don't because we know where all these cameras are. Again, we don't maintain it. We don't have any editing rights to it. We just approve it.
And there's no way Mr. Van Pelt can see that map. Is that right?
To my knowledge, no, the link is sent directly to our assistant police chief. I'll be honest with you, I've never seen the map. I've never seen the, not map, deployment plan. Because I've had no need to see the deployment plan.
Thank you.
So what, I have one question for the city. In the agreement, you agreed to a certain price for these cameras, is that correct? And then this price can change?
Not necessarily. So the cost of the 48 cameras that we entered into a contract for, their initial installation, that is on, this doesn't have a page number. It's included
Yeah,
in the
we
contract.
don't have the agreement, but so because what and I agree that these are not city records, that they are, since they are maintained by Flock. But you mentioned the URL with then pricing.
Mm-hmm.
So does that mean that the city agreed to pricing that can fluctuate?
If we have to move any of the locations. So if I may just very briefly explain step A to Z on getting these installed. The deployment plan, and correct me if I'm wrong, Jody, if I misspeak on anything. The deployment plan link, the locations are kind of they're mutually agreed to between Flock and the city. I believe we send them a general area of where we want the cameras. It's in their expertise of figuring out kind of where to place them to capture the locations that we're trying to capture. That is the deployment plan or plans. There can be multiple of them. The link is sent to us. We click, we go on and say, yep, that was our understanding. We agreed. That's good to go. If we decide in using those locations by accessing the data, again, the data that's saved is not kept on any city server as well. Again, this is a national system. They all speak together. That's why Flock is important for, catching criminal activity or helping solve crimes. If we notice that, oh, we need this turn 90 degrees, that's when the reinstall fee schedule could kick in. And that's when that pricing at that time, if they have to go remove one and put it somewhere else that we've already approved its original location, that's when that pricing fee schedule would come into play. But our contract for maintaining them for the 4 years, 4 years that we entered into is set pricing, and that was included in the agreement.
May I correct that, because that is not the actual content of the agreement?
Well, I have it right here.
Okay,
So here's the cost right here.
oh no, I know, the cost is right there, I believe you. The unique setup with Flock Safety and these devices is that the devices that they place remain the property of Flock Safety. The city does not rent them, the city does not own them, the city has no control over them. The city cannot open the devices, they cannot analyze the devices, they don't know what's inside of them. That doesn't really matter. The agreement that you have right there it includes an installation price, that is correct. It then includes access to Flock's platform, which allows law enforcement agencies and whoever else their customers are to search for, license plates or whatever. Flock specifically in the agreement says that they are not responsible for maintaining the cameras, for making sure they work, or doing anything of the sort. If a camera is damaged for any reason, if it's stolen, if a car runs into it, if a tornado hits it, the reinstall fee schedule comes into place. Flock is under no obligation to replace the camera. They can just keep billing the city whatever for the access to the software. And they could say if they wanted to, we don't feel like replacing these cameras is going to cost you $500,000 per camera for us to replace the damaged cameras.
Okay, that's,
If I may,
I think we have some of that. Does the board have any other questions or comments on this?
No, I would just say it seems like a unfortunate gap in the public records definition of documents. I mean, it's hard to believe that a city can rely on documents that nobody has access to. I mean, I don't know. It just strikes me as odd.
I can stand up and clarify a couple things if you'd like.
I agree with Barry. I don't know, personally speaking, I don't think we need much more contribution.
Yeah.
I'm ready to move forward on this. I think there's a gap. I think it's unfortunate. I don't disagree that the city doesn't have this document, right? That's the plain and simple, fact of the matter here. And because they don't have the document, there's no violation of Chapter 22. And that's what we're here to do. So that's where I'm at on this. I don't know if anyone else has any other.
Yeah, if I may, Monica, I agree with comments made by both Barry and Dan. This case has bothered me a little bit. That anyway, for the same reasons that they've articulated. But I also agree with Dan. It's probably not much we can do about it. I think his characterization that there's a gap here is pretty accurate. Thanks.
Yeah, thanks, EJ. I would agree. Do we have a motion on the dismissal order?
Move to accept the proposed dismissal order.
Second,
Dan and Barry? All in favor?
aye.
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 Any opposed? All right, the dismissal order has been approved. Yes, did anybody have any additional comments on this? I would agree. As a member of the public, I agree. I think there's a gap. It does bother me that, and the city is right. They do not own the documents. But it does kind of concern me that there's a contract out there that says, okay, we're going to go bite this. And so, and not kind of own it. So, but that is correct. They don't have the documents and don't own it. So, all right, next one, Jeff Law and Courtney Mammoth, and River Valley School Board.
this is case number 23 FC 0105. This also is a matter that came before the board last month. At that time, the board instructed staff to enter an acceptance order on this, just for review for the board. The River Valley School Board had a board meeting and took a vote to establish sports sharing activities within a neighboring school district. There was a knowledge in the community about the potential for this. However, the agenda, based on a review by the board, appeared to be quite vague. And so the board felt that was a violation. In addition, the agenda was not physically posted. It was sent out by email and posted on their website. Also a violation of what's required under Chapter 21. So This is the revised acceptance order based on the direction from the board.
Do we have Mr. Law or Ms. Mammon available for comment?
I'm here, Courtney.
All right, Ms. Mammon, would you like to respond? You have 5 minutes.
No, I have nothing to add at this time.
All right, thank you. Do we have anybody from the River Valley School Board?
Yes, this is Christy Latta from the Allers Law Firm.
Would you like to respond? You have 5 minutes.
Yes, thank you. Yeah, the district maintains that the original decision of your executive director was correct. And if you'll recall, last month, the board, took issue, I guess, with the language of the agenda and the fact that it wasn't posted on the bulletin board. And I think that we talked about the agenda and essentially the notice still meeting the judicial precedent standard that the Iowa Supreme Court has set, which is that substantial compliance is what is required. Nevertheless, the district did take action this last Monday night. They reposted the agenda. They posted it on Thursday, January 11th on the central office bulletin board. The agenda language could not have been more specific in terms of approval of the sports sharing agreement. And then at its meeting on Monday night, the board did in fact ratify and confirm its October approval of the sports sharing. So I guess even though I maintain that the initial order that went before the board in December was proper and correct, I think in light of the developments between now and then, there's really no further case or controversy at issue. The complainants have, their issues have been rectified and cured. The Iowa Supreme Court says that local government bodies can do that they can cure alleged violations after the fact. So we've done that. And I guess I'm looking at your statutory charge for acceptance and dismissal, and I don't see a basis for accepting it because I'm looking at a chapter 23 there where it talks about the idea of claims that are without merit or involve harmless error, and I think that's what we're looking at here. It's 23.8 subsection 2. So what I'm hoping for and requesting is that at this point the dismissal order can actually be approved and implemented. I just don't see a basis for moving this complaint forward.
Thank you, Ms. Latta. Board comments?
Well, do we ever do that, or we allow them to cure the violation after the fact?
I don't remember a case that we have. Barry, Julie, do you remember?
Well, sometimes people do change their course of action because of the investigation, but I'm not sure. Then it's up to the board whether their discretion and then the move ahead is an acceptance order. Behavior is altered.
If we do accept the acceptance order, what would be the next step?
The next step would be working with the parties for an informal resolution, which could include training. It could include asking them to recognize that there were potential violations, asking them to put in place policies to ensure it doesn't occur again, those types of things.
Would they have to do any kind of, would you have to do any kind of training? I mean,
We always include that as part of an informal resolution.
okay.
Well, I would agree with Julie that it's good that bodies decide that a different process might be better, but I still believe that what happened the first time was not a good idea, and I think they could benefit from the training.
I agree. I think that in my mind's eye, there was not substantial compliance in the first instance. And I don't think the ratification rectifies it. And I think everybody would benefit by the training and guidance of the staff. So I support the recommendation.
Do I have a motion and a second? On the acceptance order,
I'll move the acceptance order.
Julie's moved. Do I have a second?
I would second.
Joan is seconded. All in favor?
Aye.
Aye.
Aye. Any opposed? All right. Approval of the acceptance order. Do we have any other comments on this one? Let's go on to, Ellen O'Malley and Pleasant Grove trustees.
All right, this is case number 23FC0117. In this case, Ellen O'Malley filed a formal complaint alleging the Pleasant Grove Township trustees violated Iowa Code Chapter 21. On September 29th, trustee Norm Fry and Township Clerk Ray White removed the Pleasantville Cemetery grave digger from his duties. No other trustees were present to approve such action. In reviewing this complaint, it appears that a trustee meeting was scheduled for October 7th, but due to a conflict, it would be a short meeting. So 2 trustees were notified that the meeting would be rescheduled. However, a meeting went forward with 1 trustee and the clerk because individuals from the community were going to be in attendance. When the scheduled committee occurred, there was not a quorum of trustees. So there could not be technically a meeting under Chapter 21, and because no quorum was met, no action could be taken by the trustees. This is an unusual situation. However, because this complaint involved just 1 trustee present and the clerk, there's no meeting that occurred, no quorum of the government body, and the trustees could not take action. There is a footnote suggesting the county attorney meet with the trustees to review Chapter 21 and make sure that they understand the requirement to have a quorum to take action under their purview. It's recommended that this be dismissed because without a quorum, there is by definition no meeting.
Great. Do we have Ms. O'Malley available for comment? Do we have anybody from the Pleasant Grove Township? Board comments?
This is straightforward. I move to accept the proposed dismissal order.
All right,
Second.
Dan, all right, Dan and EJ, all in favor of the dismissal?
Aye.
Aye.
Any opposed? Any other comments? All right. Next one, Adam McCall in the city of Elkhorn.
This is case number 23FC0125. This also should be a straightforward case. Mr. McCall filed complaint alleging the city had not replied to his records request. In response, the city attorney stated the city had identified 86 records and that they would be released upon payment of the cost. The city and Mr. McCall worked together. Ultimately, on January 8th, Mr. McCall did receive all of the records he had requested. And we did confirm with him that he received all his records, so it's recommended that this be dismissed.
Do we have Mr. McCall available? Or someone from the city of Elkhorn? Any board comments?
A lot of work out. Move to accept the proposed dismissal order.
Second.
Dan and Joel, moved and seconded, all in favor?
Aye.
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 Any opposed? Any additional comments? All right, dismissal approved. Okay, next one, Scott Flynn and the Mid Prairie Community School District.
All right, this is case number 23FC0128. In this case, Mr. Flynn submitted a records request with the district in September of 2023, requesting a copy of all exit interviews completed with respect to all employees that ended their employment during the 2022-23 school year, including all forms completed, summaries, and reports based on the exit interview. In addition, he alleges that Superintendent Stone had provided the board with a summary of the findings of the exit interviews at a district meeting in August. Through a series of communications, Mr. Flynn was notified that the district was withholding responsive documents as confidential under Iowa Code 22.718 and stated that there were no written summaries and reports based on exit interviews. The district states that that report was oral and nothing was written or available to provide beyond what was shown in the minutes. In responding to this complaint, the district also states that exit interviews would be confidential under Iowa Code section 22.711 because it's personal information and confidential personnel records. The question in this case is under 22.718, whether all the requirements for that would apply. In this case, exit interviews were conducted by the district. For the first requirement under 22.718, these are not required by law, rule, or procedure. So therefore, that information, that area is met. In addition, exit interviews would elicit information about ways that the employer could improve the working environment. It would be important that that information be treated as confidential to allow for candor. And because of exit interviews, the district also could be reasonably believe individuals would be discouraged from communicating with the district if the information was made public. No one has provided consent for their information to be provided. The main issue in this case is whether an individual who's resigned employment are individuals outside the government or whether they are still within the government. In the city of Sioux City, the court has held that job applications are communications from individuals outside the government before they started their employment. And in this case, exit interviews by the district were only provided and completed by individuals after they had submitted their resignation from employment with the district. Because the individuals had resigned, they would likely be considered outside government. However, if they are still considered within in the government, an exit interview would likely fall within the confidentiality parameters of 22.711. And an exit interview is basically an investigation into a resignation of an individual. A resignation letter is outside the limited scope of a resignation and the termination, and that this board has held that those resignation letters are retained as confidential under 22.711. For these reasons, it's recommended that exit interviews are allowed to be considered confidential and that this case be dismissed.
Do we have Mr. Flynn? Would you like to comment, Mr. Flynn? You have 5 minutes.
I certainly would appreciate the opportunity to address the board. In this request, we believe that the public has an interest in determining whether or not the district is appropriately acting to ensure that there is a welcoming and inviting environment for employees of the district. The district experienced an unusually high number of staff that left the district in more recent years. Obviously, there's much to surmise that COVID probably had some impact in that, but certainly by the spring of 2023, those circumstances had changed. The district in this case has advanced the argument that individuals that have submitted resignations are no longer employees of the district, so they're therefore outside the government. It seems a bit preposterous that this would be the case. Now, it might be a closer issue if some of these individuals had completed their exit interviews after leaving their employment by the district. But I've been able to verify that at least one individual that departed from the district at the end of the school year 2023 was requested and had completed the process of doing an exit interview with the district. However, the district considers this immaterial as to the heart of the matter. Certainly, an exit interview can be differentiated from the situation of individuals applying for a job. So it would appear to be significantly different from category of job applicants, and certainly job applicants are outside the employment of the district, are not part of the government body. And those records certainly would fall within the purviews of 22-7-18. The district has also advanced the argument that the records requested here, if they would not fall under subsection 18, would be exempt under 22-7-11. However, to prevail on that, the records that have been requested would actually have to be part of a personnel file. And even in that case, they would have to be personal information contained within a personnel file. Now, the district, when it requests a written exit interview, they do both written and personal or in-person interviews, provides the potentially departing employee the opportunity to complete a Google form. The instructions on that exit interview read as follows: please take a moment to complete the exit survey. Your response will help us improve employment practices. Your responses can only be accessed by the Human Resources Coordinator and will only be shared in the aggregate. This survey will not be included in your personnel file. So it would certainly believe, or seem to me, that the district does not intend to include this within the personnel file of a departing employee. I would also point out that within the category of individuals that departed from employment with the district in 2023, there are individuals that both had their employment terminated and those that resigned from the district. All of them were requested to complete exit interviews as part of their departure from the district. The other thing that the district does not do and is involved in the category or decision, their evaluation under 22-7-18, is the district does not explain why the information contained in the exit interviews cannot be shared without identifying the individuals that provided that information. Well, certainly those individuals that have resigned or have had their employment terminated are the ones that complete the exit interviews. There's no need to connect the responses to the actual individuals submitting them. The district doesn't provide a reason as to why the names cannot be redacted from the responses received from those individuals submitting the exit interviews. And when there are, at least to my knowledge, 30+ employees that departed the district at the end of or during the 2022-2023 school year, it would certainly seem that it's not a very finite group, that it would be easy to identify the specific responses and tie them to a particular individual.
All right, thank you, Lynn. Do we have any in Prairie Community School District who would like to respond?
Yes, this is Brett Nitsky from the Allers Law Firm, representing the Mid-Prairie Community School District. The district believes that the executive director's proposed dismissal order appropriately reviewed the facts of the case and applied the law to the facts, and specifically correctly found that the elements of 22.718 were met. In addition, the district believes that 22.711 would be applicable to the information requested. In terms of, stating that there's a public interest in determining whether the district appropriately was creating an environment, I will note that there was a verbal update provided by the superintendent to the board in an open board meeting without sharing the specifics of this information. So anything that the board may be concerned about in regard to any employees exiting is something that's within the purview of the local school board to address. They already have that information. In terms of the resignations or whether someone's terminated, that doesn't change the board's analysis, or shouldn't change the board's analysis under the law. These people were exiting the district, and that is one of the elements in 22.718. that your executive director found was met. In regard to the fact that these individuals would be difficult to identify, anyone in the public could look to see who are employees of the district in the prior school year and who are the employees of the school district in the current school year. That information's on the district's website. And so that's the reason why, there's a concern about identifying this information, because some of the information that the individuals could have shared and did share in those exit interviews was specific enough and discreet enough that if this information was turned over, those individuals who provided that information with the understanding that that information would remain confidential could be then identified by the public. And so for all those reasons, the district believes that the executive director's review of this case, analysis of the laws as it is applied to the facts, and the determination that there was no violation of the law was correct. And the district requests that the board adopt the proposed dismissal order. Thank you.
Thank you, Mr. Geschke. All right, board comments.
I think, go ahead.
No, I don't have it.
I was just going to say that I think that for districts that practice that, sometimes the aggregate data about that is used for, getting better at whatever it is that are the issues. But I totally agree with the dismissal order, because it seems that that would be confidential to dismiss them or to make them open to anyone.
Hats off to you, Erica, and whoever else worked on this. This certainly was not an easy case to figure out, and I agree. Make a motion to approve the proposed dismissal order.
Second.
Dan and Barry, motion and a second. All in favor?
Aye.
Aye.
Any opposed? Any additional comments?
I agree with Dan. Erica did a good job on this.
Thank you. All right, next case, Keegan Jervis and Swan City, the Swan City Council.
This is case number 23 FC 0130. In this case, Mr. Jarvis filed the complaint alleging Swan City Council violated Iowa Code Chapter 21 on November 14, 2023. He alleges that at the council meeting, a council member declared that we are now going into the closed session portion of our meeting. Any people not on the current council must leave and will be invited back in after the session is over. He points out several violations regarding this as related to Iowa Code Chapter 21. In responding, the attorney for the council stated that the normal procedure for the board is to have one meeting per month. The council does keep minutes of all its public meetings as required under Chapter 21. He, however, was unaware the council would attempt to go into closed session on November 14. And after the meeting, he has met with the council to discuss when they can go into closed session and how to rectify the actions. The city did provide an audio recording and detailed minutes of the closed session. There were several deficiencies. The agenda did not indicate that council would be going to closed session. A stated purpose aligning with that closed session also was not provided. A motion was not made to enter into the closed session. A vote of the council had not indicated each member's determination to enter a closed session, and minutes of the closed session indicated that a final vote was actually taken during the closed session, also in violation of Iowa Code Chapter 21.5. Each of these violations have been acknowledged by the city. In addition, there was no actual time listed for the meeting on the notice for that meeting. Based on these deficiencies and the city's admission that they did violate Chapter 21 in this case, it's recommended that this case be accepted by the board.
Is Mr. Jarvis available for comment? Is there anybody with the city of, Swan available to comment?
Yes, yes, ma'am. Nicholas Bailey, attorney for the city.
All right, you've got 5 minutes if you'd like to respond.
Thank you, ma'am. Members of the board, we would rely upon the original written response provided by my office. I did meet with the city after this meeting. I would agree, based on review of both the minutes and the audio, I would agree that there are several deficiencies that we have gone over, I have gone over with the city in what they did on November 14th. Just as a matter of update, and then we can talk about the proposed decision. As a matter of update, since then, they have had a meeting on their regularly scheduled meeting on December 5th. They did vacate the prior decision to go into closed session. They have vacated the vote taken during the closed session. They released, not only does the board have a copy of the audio and the minutes, but they released them to the public. And so basically no action was taken on anything that was held in the closed session. Myself and now the city council understands the violations and that what they did not comply with Chapter 21, and would welcome any other questions. But basically, that's the remedy that's been, and that's indicated in my letter to the board. Those are the things that I felt eventually, whether this case is accepted or not, that the board would want to see. And that we would want to see to make sure that this particular city is complying with both chapters 21 and 22, 21 being the issue here. And so those are things that they're doing going forward. I myself was at the December 5th meeting and was present by phone to provide advice at the January meeting. And they are now complying with the dictates of Chapter 21. I understand, much like a prior respondent, I don't remember who it was, but a prior respondent said that we feel that we've taken actions to do what the board would want to see to remedy these violations. I understand that as a matter of precedence, or just as a matter of course, that because there is a legal and factual basis to believe the violations occurred, I understand this may be accepted. The city seems open and willing to work with myself and with the board to remedy any past violations, get additional education on the subject, and basically act in a manner so that these sorts of things don't happen again. And that's all I would have, but would welcome any questions from the board.
Thank you, Mr. Bailey. And I will say, Brett did point it out to me, Mr. Jarvis did provide a response. It is in your minutes. He did send an email. Do we have any board discussion on this?
I think this is straight as well.
Yeah, no, other than I'm happy to learn where Swan, Iowa is. Thank you.
I didn't want to admit I.
Yeah, I believe it's close to, I think it's in Warren County or close to Warren County.
Marion County.
Marion County, okay. Thank you, Mr. Bailey.
Runnels and Pleasantville.
Oh, I didn't know that either. That's one town I didn't know in Iowa.
It's one of the great things about this position.
Yeah.
All right.
I just wanted to say, I appreciate Mr. Bailey's comments and willingness to let the board decision, or go with the board decision to accept.
Yeah, I would agree with that. Jonah, I appreciate that the city has taken some action in order to correct it, but I think they could benefit from our training.
Definitely. Do I have a motion in a second?
I would move to accept the complaint.
Second.
Is that Barry?
Yeah.
All right. Barry, motion in a second. All in favor?
Aye.
Aye.
Any opposed? Any more comments on that? All right, let's move on to, Michael Merritt and, Powashik County.
All right, this is case number 23 FC 0123. In this case, Mr. Merritt filed a formal complaint alleging Powashik County violated Iowa Code Chapter 22. He alleges the county failed to provide a required response within the timeframes articulated in Iowa Code Section 22.8. He alleges that numerous status requests were sent to county employees on several occasions requesting status updates, and these were disregarded for weeks. In response, the county stated that Mr. Merritt made a request for an audio recording of a call to the county dispatch related to an incident on August 4, 2023. According to the documents provided by Mr. Merritt, this request was made over the phone and by email. The email request from Mr. Merritt was made on September 26 and was responded to by Deputy Disney after forwarding it to the records custodian, Deputy Meyer. The county attorney also confirmed that the response from Deputy Meyer that the record was not available meant that the record did not exist. So there was no record to provide to Mr. Merritt responding to the request. The documents provided by Mr. Merritt plainly show that Powashik County's office promptly responded to his request. IPAB staff reviewed the timeline of communications provided by Mr. Merritt. Within them, there was an email with 2 records requests made by him. This complaint focused on the second request made to the county, which was for dispatch telephone audio on August 4, 2023. The first request was for body camera footage from that date. That was promptly provided to Mr. Merritt by the Grinnell Police Department and is not part of this complaint. After thorough review of the emails, Mr. Merritt did make his first request for a telephone recording from the county on August 8, 2023. This request, however, was buried within the text of a lengthy email. And at the beginning of that same email, Mr. Merritt had clearly stated he was making a records request for that body camera footage from Grinnell Police Department, and which again was promptly responded to. Another request on August 30th was made by Mr. Merritt to the county sheriff for the audio recording for August 4, 2022, which we know is 2023. On September 26, Mr. Merritt did make a request to the county records custodians for that audio. He made that request by phone and email. Receipt of this request was promptly acknowledged by the county. And on September 27, the county informed Mr. Merritt by email the audio recording did not exist, so it could not be provided. It's not unreasonable that the county did not find the request that was buried within an email that was also sent to multiple parties on August 8, 2023. We have stated that a records request should be clearly communicated and should not, somebody should not have to dig through a lengthy email of unrelated text and information to find one. And then there was additional request on August 30 that was made to the sheriff. So even if that request was received by the county, Mr. Merritt received notice the record he requested did not exist on September 27. This response was 1 day after the request was clearly submitted to the records custodian and 29 days after it was emailed to the sheriff. Chapter 22 does not have an absolute deadline for responding to records requests. So based on the fact that this complaint was that the records request was not submitted within the time frame articulated in 22.8, and the Iowa Supreme Court has stated a 20-day period for determining whether a record is confidential is not a time frame extrapolated to other contexts. There's no violation under these facts when the initial records request is not clearly communicated and the county responded within at least 29 days to the request that was communicated. In this case, delay caused by a failure to identify a records request and question as to whether or not one may have been received. And once the record was clearly articulated to the custodian, it was promptly acknowledged and communicated. It's recommended that this be dismissed as legally insufficient.
Mr. Merritt, speak. You have 5 minutes.
I appreciate Executive Director's version of the events, but I believe the evidence provides us a conclusion as a complete fictional representation of what actually happened. I will agree with your assessment that I do talk too much. I think that's probably a popular, common assessment that I have a plethora of words in my discussions, and I apologize for that. But if we were to go ahead and dismiss the original request on 08 August 2023 and just discard that one, we still have to look at the evidence of the request was made on 30 August 2023 to Sheriff Kriegel that was also disregarded. That was actually very articulate with regards to pointing attention to the original email that was on 08 August 2003 that was disregarded. But as the executive director stipulated, it was rather lengthy, so we'll disregard this rate. It doesn't account for the disregard of the county for ignoring the 30 August. We've stipulated that Don Disney is a record custodian and Deputy Meyer is a record custodian. The Powashik County, Iowa received record requests on 12 September 2023. I emailed them on 12 September 2023. The 13th and 15th, I included 30 individuals of Powashik County, Iowa, including Deputy Meyer, who responded, and Don Disney, who is the alleged records clerk. So for them to not have been aware of this record request is completely absurd. And I've got information that has provided me a conclusion that these records only stored for 2 months. So as you can see, the county of Powashik County, Iowa did not respond until that 2-month threshold approximately. I also believe the executive director actually provided prejudice against our request by bringing up that this request, the complaint was not filed until 2 months later, which is completely irrelevant given the fact that Iowa Code Section 23.7 gives a citizen a right to file a complaint within 60 days. My complaint came in at 59 days. So what boils down to the culmination of his complaint and its conclusion is whether the falsehoods and redirection of language by 2 licensed lawyers in the state of Iowa is going to allow Iowa government bodies to ignore record requests for several weeks, allowing an event where data that has a threshold of supersession of 60 days, 90 days, whatever the limit is, they just disregard those requests until the data is no longer available or deleted. So the real question here is how Powashik County, Iowa attorney is stipulating that he didn't receive a request until the 26th of September when the historical record shows that he was included on the emails on the 12th, 13th, and 15th. That's my recollection. I'd have to look at my computer. But just on a personal note, the reason it took me 59 days to file this complaint, I have significant asthma. I have very bad health issues. And as my medical records show, which I'm more than willing to show this board, I was diagnosed with COVID in October because my partner is a certified medical professional, CMA, and she got COVID, I got COVID, and I already have a hard time breathing as it is. So I was pretty much out completely the whole month of October, just in bed trying to breathe. So that's irrelevant, and I believe I'm just disappointed. I served this country for 20 years, and I came to you guys for help 2 years ago, and for instance, today I got a record request, a response to the request I'm sure you all have seen about the 3 or 4 emails regarding this board and the search for the word vexatious in my last name. I got a response from the government body today requesting $400,000 to perform that search. And that's not including the legal fees. So when we tack on the legal fees and the amount that you're talking possibly $500,000. So I'm not your enemy. I don't appreciate the fact this board falsely accused me of a misdemeanor across the state of Iowa when I've done nothing. All I've tried to do is bring awareness to this board about the evidence of local Iowa government bodies not properly tabulating fees regarding the storage and preservation of data on third-party commercial systems. I was in IT and Cryptology for 20 years. I've got a skill set of experience I believe is lacking in this board. With all due respect, sir, your analysis of what was confidential in Iowa Code Section 22.7 in the last July meeting, I disagree with. I believe I can build a case to show that your assessment was inaccurate. I don't know your professional history. I don't know if you have an IT background, but everything I'm publishing that's consolidated, that have been criminalized as cybersecurity threat is all public records. You can go to ICANN. It's like the U.S. Postal Service. The DNS is public information that provides servers a way of tabulating where information is across the globe. And I just feel a lot of arrogance and contempt in this room toward me. That's my perception. Not by all parties. There's a few good people in here, and I appreciate that. But it disappoints me what I've experienced the last 5 years since I've retired. It just disappoints me. And it really is irrelevant whether this board dismisses this complaint or not. I intend to file a complaint against 2 licensed lawyers involved. I believe it misrepresented.
Thank you, Mr. Barrett. Your 5 minutes are up. Thank you. Do we have anybody from Powashik County who would like to respond? All right, do we have any board comments? Do I have a motion?
I agree with the analysis and I'd move to accept the proposed dismissal order.
I have a move. Do I have a second?
Second.
Joel? All in favor of approving the dismissal order?
Aye.
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 Any opposed? Any further board discussion? All right, thank you, Mr. Barry. All right. Vicky Garski and Montour City Council.
This is case number 23 FC0136. In this case, Ms. Garsky filed a formal complaint alleging the city violated Iowa Code Chapter 21. The Montour City Council consists of 5 members. After their formal meeting on December 5, 2023, the complainant alleges that she received a call from the city clerk informing her that 3 of the 5 council members had gathered together in discussion after the meeting. In response to the complaint, the city clerk stated she did see the council members gathered in discussion after the meeting and advised them that 3 standing together could be construed as a quorum. The council members stated in response to the clerk they were not discussing city business. The clerk reminded them that anyone from outside would not be able to tell what they were discussing, only that there was a quorum. Here the issue is whether the gathering of 3 council members meets the definition of a meeting. The gathering did consist of a majority of the council. The complainant, however, does not allege the members were discussing matters within the scope of their policymaking, nor did the clerk claim to have overheard them discussing such matters. The council members themselves stated they were not discussing such matters. In order for a meeting to occur, there must be deliberation or action on matters within the scope of the body policymaking duties. In this case, that element appears to be absent here, so it's recommended dismissal.
Ms. Gursky, are you on the phone or would like to respond? Do we have anybody from the city of Montour? All right, any board comments? Do I have a motion and a second?
Move to accept the proposed dismissal order.
Second.
Dan and Barry, all in favor?
Aye.
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 Any opposed? Any other comments? All right. Oh, Dan and Barry. Dan and Barry.
Unanimous. Have a couple withdrawals. You guys have emails of those.
Lots of cases today. Great. Committee reports.
I'm gonna plan to, hold a, communications committee next month prior to the start of this meeting. Or just after this meeting, set a time, but we'll get together. It's been a little bit of time since we've met, but the idea would be to examine, what we're producing, in terms of outreach to the public and, training type, opportunities.
You remind everybody who's on that committee.
Yeah, Monica and
It's a small thing.
It's just you, Monica. Good luck. Maybe
I'm
Jackie.
gonna have to look it up.
Okay, all right.
I'm sorry.
That's okay.
It is Jackie.
I'm actually probably thinking 5 years ago. That's why,
I bet.
that's why I'm messing this up. So.
Legislative.
All right, legislative, the legislature came back into session, and there have been a couple of bills that have been introduced already, in addition to the bills, that we had left over from last session. Because I have not gone through a whole legislative session with the board, I'm not sure how you guys want to work with the legislation that's coming through. If it's something where the legislative committee wants to receive that information, wants to have a standing meeting to discuss legislation that's been introduced, or if there's any particular way that the legislative committee has worked during the active legislative session that you would like to continue or move forward.
Would you anticipate there be any movement on any of those bills prior to our next meeting?
So I can't remember, Dan, do you know the first funnel date? It's usually in March. I don't have it right.
Yeah, well, it's next expedited session, so. February 16th, actually.
February 15th. So I'll go through a couple of bills that have been introduced and kind of where they are, as well as our bills. One that was just introduced, I believe yesterday, is House File 2062. This increases the penalties for violation of Chapter 21 from $500 to $5,000.
Thank you.
And also increases violations for somebody who knowingly participates in a violation from $2,500 to $25,000. It also requires a mandatory member education course for individuals who are public after election or appointment to a governmental body. So that one was just introduced. It is in the House State Government, and we are working on a fiscal note regarding that. There's also House Study Bill 531. I'm not sure, House Study Bill 531. This one was introduced last week, and they had a subcommittee on the 16th, which recommended passage. This one is adding booking photographs to a list of confidential documents under 22.7. So there's that one. There's some reasons when it would be disclosed and reasons when it would not. Then there's our bills, our IPIP bills for increasing our jurisdiction from 60 days to 90 days. Last year, this passed the House and stalled in the Senate. So far, there's been no action in 2024. In addition to our House File 350, which was a requirement of promptly responding. Again, this passed the House last year. Was in unfinished business in the Senate. I have not seen any action yet this year. There was also a bill on a definition of a meeting, which allowed for a gathering of members comprised of 3 members or less to go to a political party or civic organization. That was there's been no action on that in 2024 yet. There is also House File 409, which requires 30 minutes of public comment at school boards, requiring at least 2 minutes per person unless they violate good conduct. Can end early if all speakers are done. And this has been sent to a subcommittee in the House, but no meeting has yet been scheduled. And those are the ones that have been active so far, and anticipate probably some additional ones coming up.
Those enhanced penalties are unbelievable.
Yeah.
$25,000 for an intentional, and $5,000 for a regular violation. I mean, that's incredible.
Be great if we could get to keep the fines.
Where is that coming from?
That was filed by Representative Moore. I believe he's out of Davenport.
Wow. I'm gonna hold off on my reappointment.
So, if you guys want to think about it, otherwise I can just, informationally send all this to the legislative committee for review. Or unless there's another way that you guys want to move forward. Typically, unless it's our bill, we typically monitor and just provide any expertise that we have on the matter.
I would suggest, Erica, that you put together the bills that you think are going forward and send the legislative committee and anybody else that wants them copies of the bills and maybe kind of a commentary if you have any thoughts. And then we can, if we feel it appropriate, we can call a meeting.
All right, I will do
That
that.
makes sense, Barry, Joel?
Yeah, I want to make sure I get that off to my city attorney brothers and sisters immediately. Boy.
BJ and Barry, if we have a meeting, we still need to, whatever we decide in that meeting, we need to bring back before the board. If we're going to give guidance, wouldn't that to Erica, wouldn't that would be the case, correct?
Yeah, I think that's what I intend, to take a look at it, see what we got, and then we can make some kind of comment to the board and let the board make a decision at the next meeting. I don't know what else we can do other than that. But we can all look at it and then decide whether, I mean, I think we can communicate with Erica and decide whether or not we want to come together or have it by phone or whatever we want to do.
Yeah, I think if we can have maybe a week prior to our next board meeting. I don't think.
Oh, yeah, I would hope maybe to have it sooner than that.
Even next week would work for me.
Yeah, I would agree. Whenever Erica can get to it, it's sooner than better, or sooner than later.
Mm-hmm.
All right, I'll work on setting up a meeting for the legislative committee next week. And I will send out to the entire board the current active bills, just so you all have it.
Yeah, good idea. And then what we can do is, if we look at it and we don't want to have it, at least we got a date on the calendar.
Yep.
And then the rules committee, I know Daniel sent a memo on the red tape review. Do you want to cover that? Or I read through it. Did everybody else get a chance to review that?
Yeah, so he just reviewed the red tape review. There's a new program, project management software called Esper, if you've heard that word, to help with the rule review. And so he provided a memo. He is not here today. Yes, yes, there were during the blizzard. So,
He's where?
oh, so Daniel had at the last meeting, he shared that he is he's now had a baby. It occurred, she came during the blizzard.
Wow. Well, that's absurd.
So he will be back soon,
Yeah.
but he's otherwise busy. So, but once he returns, I know he's going to start working on this. Esper has gone live this week, so I know he wants to work with the committee on that.
Status report. The office.
So I just want to draw your attention to the annual report that we put together we have to, under the chapter 23, have to provide an annual report to the legislature. We put together a draft, would be open to any comments or changes that the board wants. I tried to incorporate some of the information that we now are able to gather with Salesforce being fully electronic. All of our case complaints can be better tracked regarding what they involve, how they were resolved and such. Also, I know that Brett had sent out a notice of your bios in the board. So if there are any changes in there that we missed or that you would like to have us make, so we might have one, then let us know so we can get those changed before we provide this to the legislature.
And in the past, was approved releasing a triangle. With some amendments needed.
So I think Brett is asking for somebody to provide a motion on that. With any
changes.
amendments that we need to make for Joel. Joel has a new
I have
job.
a new job, so.
Congratulations.
Thank you. I'll second that.
All right, Joel is second. All right.
Change.
All, so all in favor of approving the annual report with changes? All in favor, aye.
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 Any opposed? All right. Budget update, Brett.
Everything is, good with the budget. We anticipate, no concerns with this fiscal year that we're in. I wouldn't call it a capital expenditure, but, we're gonna try and capture an owl, through the internet ordering it. So once that owl flies in, we'll pay for it, but, it's relatively inexpensive. It's about $1,400 expense. And if this proves out our feedback, we'll go ahead with that expenditure.
Are you talking about this device?
Yeah.
But is this not permanent?
We borrowed it to test it out.
This is what we use for our school board meetings, very successfully.
I mean, I'm saying this is a different breed of an owl.
Oh.
White owl.
This one is native to,
Yeah, Capitol
So
Complex.
Brett's gonna spend a lot of late nights trying
Ours
to
is
catch one.
Judge.
Yeah, we gotta train the owl.
It certainly eliminates the background noise from people who don't.
And we won't have to use the conference call anymore.
Yeah. He seems to make some spontaneous.
It does it.
It moves. So if you look at, when you look at the videotape, or look at, not videotape, look at YouTube when they're done for the meeting, because you'll be able to see it. As people are speaking, the owl moves, and then it will move around the room.
I don't see them.
Yeah,
But
on the video.
It's on the,
On the
on the
video.
black part on the top is where the camera is.
Yeah. Yeah, so you can actually see it here.
And that's the big thing that we're hearing on,
I-
PG, whatever.
Yeah.
So now that I start talking, the owl should come over to me. And
And then across the top, it does a panoramic of the room. So at all times.
And we can pull it up on YouTube.
Yes.
So we've created an Iowa Public Information Board YouTube channel. And right now this should be streaming live. So anyone we checked it and it was working before. So we'll check, it should save it, and then we can, keep all of our meetings automatically on the YouTube.
I'm surprised it's that inexpensive.
And I will tell you as a voice of experience, once you're done with it, I would set it on the floor. Because if it falls from that, it will break.
Well, you clipped its wings. It's like a fly with it.
Yeah. Well, its eyes will become crinkled.
We'll make Daniel take care of it. He can feed and water.
Presentations and training.
Monday, going to the city of Elgin, also presenting to the county assessors group in March. I've been invited to Drake journalism class. A couple other requests have come in but not been finalized. So we continue to work on that. I look forward to the communication committee working on outreach to the public and additional ways that we can get training out there.
District court update.
So there's a couple of appeals at the district court. And a swarm appeal is the hearing for that in Henry County is on January 25th. There's also an appeal here in Polk County Brief is due on the 24th, and a hearing is scheduled for February 16th.
Are the appeals dismissals?
Yes.
Is that right? The next board meeting is at 11 a.m. on?
Yeah.
Yes, we
February
had some
15th.
issues with getting the room,
Okay,
so we had to move the board meeting up a little bit.
okay. So the next board meeting will be February 15th. But no, it's going to be at 11 a.m. instead of the normal 1 p.m.
And it will be in the boardroom that's on the second floor that we met in occasionally. This room was unavailable, and that room has a meeting starting at 3 o'clock. So,
I don't know, 11 o'clock.
We'll have the owl, Barry.
Yes.
Yeah. So, I've got a couple questions or a couple comments about the video.
Yes.
The question first, is there a form for reappointment or what's the process?
So,
There is.
yes, there is, it's on, all of a sudden I can't remember it. I can send it to you, Barry,
Yeah.
and I think we'll also post something on our website, to get people who want to apply to be on the board, because the governor is gonna have to make some appointments. I don't know, Julie, if you're reappointing or if you're, okay. So we will have, two vacancies, assuming Barry and Joan both, I think I saw yours, Joan.
Yes, I have already
Assume
completed it.
that Barry reapplies, but we will have at least two vacancies.
I'll be finishing my second term. So, city report.
Okay, couple of comments.
April 1st, I believe, is when the appointment starts.
So March is my last meeting.
Couple of comments about the video. I mean, it works pretty well. We need more microphones. I mean, the farther you are away from the microphone, the more difficult it is, at least for me. I don't know about you, EJ. Sometimes it's hard to understand what people are saying. There's also on my screen, and I don't know enough about this program to be able to do anything about this, but anybody that calls in has a tile up and they're blank. And the more tiles you've got on here, the smaller the tiles become. And the impact is, first of all, you can't see much of the board room. But secondly, anybody else that's on, has a camera on, the tiles get much smaller. So when we started the meeting, we had about 6 people with tiles up, no camera, just taking up space. It's also impossible to tell who's on. There's somebody on right now with a 515 area code. I don't know who that is. If that's a board member, is that Jackie maybe? I can't tell what other board members are on. I don't know if there's anything you could do about that or not.
We appreciate.
I agree with Barry. I make the same observations.
Okay, those are good observations. We're trying to figure out how we can provide access to people, the complainants and respondents virtually. So I don't know if there's a way we can work and see if there's some way under Google Meets to have a different view that doesn't let the tiles show up, because.
So for clarification, is the general public accessing the meeting this way as well?
The general public can access it through the YouTube Live, just on YouTube. So they're passively watching it. For individuals who had specific complaints this meeting, we had either the conference phone, or we also provided them the Google Meet link so that they could join that way, because we weren't 100% confident testing this out.
Sure. So what does he say? I can't understand what word he's saying. People who have tiles?
So right now, if you look at the screen, since it's a Google Meet and there's multiple people on,
yes,
it's every person gets a little space on the screen.
I understand, but some of them are unidentified. Is that what he's saying? Okay.
Yeah, but it works pretty well. It's not perfect, and hopefully we can work out some of the wrinkles, but it's pretty good.
We don't tend to have problems with people being able to hear that I know of. based on the proximity to the owl camera.
So I think we don't, I think this is just the owl. I think the speakers are tied to the conference, call.
Gotcha.
And so we are looking at having an additional speaker. I don't know if it's, you can only get one or if there's two speakers, looking
I
at
see.
additional
Okay.
speakers to have tied directly to the owl.
Okay.
Baby
Thank you.
owls.
And on this end, Barry, you've never sounded better.
Oh, I got a great picture of EJ, the whole meeting. That's, you know, what the thing.
I don't seem like I'm in a hurry, but if it's been
Yes.
snowing.
Are
for
you
the
back
last while-
criticizing the equipment, Barry? Is that what you're saying?
All right, so I'm gonna, so do I have a motion, a second for adjournment?
So
Second.
Joel and Julie, all in favor?
Aye.
Any opposed?
Aye.
Aye, all right,
3 p.m.
3 p.m.
Jim.
Winter driving somewhere.
Would you like to take my note?
I apologize for my tardiness. There were no spaces down below, so I had to do parallel park on a one-way, which is problematic with a
I would have
snowbank.
just forgotten and left. I don't parallel park.
I didn't fall, so
That's
that's
good.
You know, there are plenty of handicap spaces and I have a handicap thing that I used to take my sister with me.
Oh,
I
okay.
forgot to hang it, so I
Oh.
went and did.
Did you park down below though?
Yeah.
Okay. Yeah, it was.
Yeah,